intersection of law and everyday life. We strive to cover it all, help you get your business right. At the corner of legal insight and understanding, we hope to keep your knowledge ever expanding. Welcome to Law Street with GHR. We got law education accessible to all. Oh, welcome to Law Street with GHR. We're informing the community, so come and get involved.
Hello and welcome to another episode of Law Street at the intersection of law and everyday life. I'm Lisa Rooms and we have with us today our partner Gabrielle Grant Gilpin Hudson.
Hi Lisa.
How are you?
I'm great. Thank you for having me.
All right, Gabby, what are we talking about today?
Today we're going to talk about to have and to lease homes. So we're talking about leases and terms of leases.
The title is so cute. I just love it.
Yeah, all right. We gotta keep it spicy.
We do.
Gotta keep it spicy.
All right. So to have and to leasehold. Mm-hmm. So this assumes that we're gonna be talking about lease agreements.
Yes.
So what are we talking about in terms of lease agreements?
So the first thing I want to start off by saying is that lease agreements can either be in writing or they can be oral, right? So sometimes what happens is persons are kind of informal in Jamaica and they don't actually have a written lease. Now, even when you don't have a written lease and even when you do have a written lease, there are covenants or terms, promises that are implied into the lease under the law. So meaning even if you didn't specifically say these are parts of your agreement, the law implies these as parts of your agreement.
All right. So walk us through some of these implied covenants, terms, promises.
Okay. So there are basically three main ones, but they kind of expand into four, right? So the first covenant in any lease agreement, it's just taken as a given, is the covenant of quiet enjoyment. What is that?
What is that?
It sounds like what it means what it sounds like, right? So basically it means that as a tenant, the landlord gives me the right to quiet enjoyment of the property.
So this landlord, when I have signed this lease or have made this oral lease with a landlord, they are supposed to leave me alone.
Pretty much. So the type of situation where, say a landlord just popping in on you and saying, hey, what's up? Coming to visit, saying I'm going to come by. And
that's not okay.
No. Quiet enjoyment means that you must allow me as your tenant to enjoy the property in peace and quiet.
Love that.
Right?
Love that.
So you are not to disturb them. You are not to take any authority away from them. They are the person that is in possession of the property because you have parted with that interest. You've granted them possession to your property as the tenant. So yes, you're to be able to enjoy the property free from any disturbance and interference from your landlord.
Wonderful.
101.
101. This is it's just fundamental.
Yes, correct. Now, kind of building on that, there's also the covenant not to derogate from the promise of giving me quiet enjoyment. What does that mean? Basically, it means that I, as the landlord, should not do anything to interfere with your use of the property for which it was rented.
Right. So I as the tenant, I have rented this property because I'm gonna live there and I just want to live and be happy and come home from work, and sit down and watch Netflix and be in peace, and you must allow that.
Correct. And also to kind of build on that, so basically it means that if, for example, I as the landlord live next door to the property that I've rented to you, I shouldn't be doing anything next door or on the surrounding property that interferes with your use of the property for the purpose that I rented it to you for.
Right. So you as a landlord should not be having parties every weekend when I'm trying to loud parties with loud people and doing all sorts of things when I'm just trying to just sit in and read a book.
Right, because it's like you're giving with one hand and taking away with the other. You're not allowing me to actually use a property for what you rented it to me for. Same thing applies to like a commercial lease. So if, for example, you rented me the property so that I could use it for a shop or, you know, a commercial space, and whatever you're doing next door prevents people from even coming inside. They can't come inside and park, or they can't come to me and do business.
Right.
You are interfering.
Yeah,
with
you are derogating
from the grant. Right? So building on that again. Another thing, common sense. The property needs to be fit for human habitation.
Given. and given.
Yeah, so it actually needs to be in a tenantable, a livable state of repair. It cannot be that like the floor is falling out, or
there's mold
or there's mold, or the roof is not intact and it's just
or it's
leaking
infested with all sorts of creatures.
Correct. It must be in a good standard of repair so that a person can live there with dignity. This is implied in the law.
Yes.
Right. Also, you know, like building on that, like it couldn't just be like a box with no ventilation.
Right.
That's not.
Give me a window,
fit for
please.
human habitation, right?
Yes.
So there's that. Now, the next thing, this one is actually in favor of the landlord. The tenant should not commit waste. Now, in leases these days, you're not really going to see that. But waste is, for example, like when, say I lease like an agricultural property to you.
Yes.
And you are basically cutting down the trees and not doing anything with them or things like that. It's like a very archaic thing, but you're not supposed to commit waste on the property. And you can extend that to say that you're also not supposed to be doing things that kind of allow the property to deteriorate.
Okay, yes, that's what I was thinking.
And fall out of repair.
Right.
So you're supposed to actually keep the property, you know, in reasonable condition, fair wear and tear.
So, for example, if I see that there's something that's going to affect the flooring, or I see something that's going to affect the roofing, I'm not just to ignore that.
No, at the very least, especially because generally certain types of repairs would fall on the landlord and certain types of repairs would fall on the tenant. But at the minimum, if there's something serious happening, you have a responsibility to bring it to the attention of the landlord. So when you are finished with the property, you're supposed to yield it back up to the landlord in a good and tenable state of repair.
Right.
You know?
So when my lease is done, I must, as a good tenant, ensure that I'm giving the property back to the landlord in a good condition.
Correct. So, and I mean, we're not going to be unreasonable and say things that happened to the property that weren't your fault, like acts of God.
Yes.
Or, you know, like accidents, war, things that destroy the property outside of your control. You're good for that.
Yeah.
But just the basic everyday things.
Yes.
You're supposed to keep the property in a decent state of repair.
Right.
So those are the implied covenants.
Right. So those being the implied covenants, you spoke about express covenants.
Yeah.
So these would be the covenants, for example, that are written in a lease
agreements. They're in black and white.
They're in black and white.
Right.
You cannot ignore the fact that they exist.
Yeah.
If you sat down and read the lease and you signed the lease, you saw them.
Correct.
Okay, so walk us through some of these express covenants.
Okay, so there can be many different types of express covenants, right? So under the principle of freedom of contract, you can pretty much put different things in your leases and get creative and fancy, provided it's in the the confines of the law.
Yes.
There's some stuff you can't put in there, right?
Yeah.
But just to be reasonable, and even though generally it's implied that you'd pay rent as a part of your lease, the covenant to pay rent from an express perspective, you can now write how you want that to look.
Right.
So that's where I would start. In written lease agreements, you want to specify how the rent is payable.
Yes.
Otherwise,
monthly, whatever the period
is it monthly? Is it yearly?
Right.
Are there consequences for late payments?
Right.
Is it payable on the 1st of the month, the 15th of the month? Those kind of things. And how is it to be paid over? Those are things that would be covered in your express covenant to pay rent.
Okay.
Yeah.
That sounds good. All right. So what other kind of covenants are we looking at in terms of express covenants?
Well, here is a juicy one. There is the covenant not to assign or sublet. What?
And I know where we're going.
Right.
All
So
right.
the covenant not to assign or sublet. So not to assign means that I am your tenant and I am not allowed to then take that property and assign my benefits as your tenant to somebody else.
So I cannot rent from Mr. Smith. I am Mr. Smith's tenant.
Yeah.
I cannot then pick up myself
And rent
it to Gabrielle.
Correct. That's you're essentially assigning the lease to me, and you generally cannot do that. Sometimes you might write that you can assign it with consent of the landlord, but generally, especially if we are advising the landlord, so we're the lawyers for the landlord, you don't really want them to be able to assign it.
Because then as a landlord, I don't know who that person
Correct.
is. I haven't checked that person. I haven't vetted that person.
Correct.
I don't know what that person is going to come and do with my property.
Correct. So exactly. So that's just it. That's what assigning is. Now what's subletting? So subletting is kind of like assigning, but it's doing it in pieces. So that's where I would be Mr. Smith's tenant, and now I am renting a bedroom to you and maybe a bedroom to Chris.
Oh my
right?
goodness.
So I basically sublet it where now I have 2 baby tenants under me, or maybe it is that I've just rented a bedroom to you and I'm still occupying the rest of the place.
Right.
So I've basically taken you up as like a subtenant underneath my lease.
Wow.
You don't want this, guys. No, because you don't really have control as a landlord to be able to get to the subtenant when the subtenant does things that they're not supposed to do.
Right.
Your recourse is going to be against the main tenant.
Right.
Now, another thing that this kind of is very controversial right now is what persons have been doing is renting a property and, then going ahead and putting that property up for short-term rentals.
Oh my.
All right. And it's very controversial as to whether or not that constitutes a breach of a clause that says you're not to assign or sublet. Wow. That's why you have to be very careful as a landlord how you word these clauses.
Indeed.
Or if you're a tenant, just be open and upfront with the landlord and let them know this is what you're renting the property for.
Yes.
Because at the end of the day, you cannot be just taking the property for one purpose and then now using it as an Airbnb without the landlord's knowledge. That kind of no right still.
Yeah.
No.
Agreed.
So, and kind of segues very neatly into my other point, which is a covenant that speaks to what you're allowed to use the property for. So again, if I've rented this to you for your residence, for you to then take it
for
up
me
and
and my
using
family.
it, for you to now use it for like a almost commercial purpose of running it as an Airbnb business, arguably you could be using it for a use that I have not authorized.
Right.
So again, it's very important to have the lease address what the property is allowed to be used for.
Right. So I cannot take up myself. I have rented this apartment for a residence. I cannot then be running a gym out of it or a hairdressing parlor out of it.
Or a restaurant.
Or a restaurant out of
right?
it.
And you would see, like, for example, in certain commercial complexes, they want it to be office spaces. They don't necessarily want a restaurant in there. They don't necessarily want a hairdresser parlor in there. Also, it has implications for like things like insurance. Because if I have you in the property and you're using the property for a restaurant that has like fire risk associated with it and stuff, maybe we didn't contemplate that from an insurance perspective. So it's very important to be specific about what
it should be used
people
for.
are using the property for.
Absolutely.
All right, so we spoke a little bit earlier about covenants around repairing the property, right? Generally, what you find is different written leases provide for different things in terms of repair.
Right.
But what is generally the standard, and that's why you should have a clause in your lease that addresses it, is for minor everyday repairs, and sometimes there will even be a dollar amount in there. For minor everyday repairs up to a certain dollar amount, the tenant will be responsible.
Right.
So like, if the flapper in the toilet bowl goes, you're supposed to like replace that.
Yes.
Or, a minor leak, you can get somebody to fix it up to a certain amount.
Yeah.
What's usually reasonable is about 10% or so of like the rental amount monthly in a residential lease.
Okay.
But so those little minor things as a tenant, you can go and do. And it's reasonable for the landlord to ask you to do them.
Yeah.
Now, more serious things that have longer term implications conditions for the
like
property.
the roof is leaking,
Or the electricals,
Yeah.
or things to do if you're renting somewhere with appliances included, things to do with the appliances.
Yes.
Generally, as a tenant, you don't really want trouble the landlord things. For
No,
go
I
mash
mean,
them up.
I don't really want
No,
as
as
a tenant, I'm not gonna have anybody rework this electrical.
That too, because
No,
the
no.
cost is generally for those type of repairs, like structural repairs or electrical repairs, the cost is generally more significant.
Yes.
It has a more long-term implication, and so it's kind of reasonable and fair that those things would fall to the responsibility of the landlord.
Yeah, because it's their property.
Exactly.
Yes.
So it's only in certain types of arrangements maybe where people deviate from that for certain reasons, but the general rule, big things landlord, little things tenant.
Fair enough.
Now, all right. So another thing that's pretty popular, options to renew.
So this is where I feel comfortable that this landlord is not a crazy person.
Or the tenant
and as
is
a
not that
landlord, I feel comfortable that this tenant is okay.
And they pay on time.
And they're following all the rules. I might want to say, okay, the lease is coming up to close, but actually I wouldn't mind them to stay a little longer, or I wouldn't mind to stay a little longer.
Right. So that's what options to renew generally provide for. So options to renew, and it's very important for you to have this clause worded carefully so that you don't end up in the problem of the lease renewing in perpetuity.
Oh my goodness.
Right? You could do that by accident if you don't word it properly. But options to renew should speak to the fact that well-worded one should speak to the fact that if the tenant has done everything they're supposed to do under the lease, paid on time, been a great tenant and whatever, then generally within a certain time frame before the expiration of that lease, if it's a lease for a fixed period, because not all leases are for fixed periods either, right? Then within a certain time before the expiry of that lease, the tenant can give notice that they would like to renew it on the same terms.
Okay.
Right?
Yeah.
For a certain period. Right? Sometimes the wording of that clause might carve out that the rent is to increase, or the rent is to be agreed, things like that. But it basically provides an avenue through which the tenant can say early. It's usually maybe like 90 days before the end of the lease.
Okay.
That's
a good amount of time.
Yeah, and you want it to be a good amount of time because as a landlord, you want to know if they're staying or if you need to start going and looking for a new tenant,
somebody else,
right?
yes.
So that's an example of something that needs to be carefully worded in the lease agreement.
Right. So I'm hearing a lot about carefully worded.
Yeah.
And that sounds like if I am not sure what I want, I should be asking for some assistance.
Correct. I am, and not to be biased, but it's very, very recommended that you consult with an attorney, especially as a landlord, in terms of what's in your written lease agreement.
Right.
And some of the stuff that you want to put in there. Even, for example, there's so many more things that we could address here, like how many months notice to quit you need to give if you want to end the lease early, or are you even able to end the lease early?
Right.
We also spoke a lot about things that have to do with residential leases, but even with commercial leases, especially, Lisa, let me tell you, a commercial lease is not something that you should just be taking off the internet and rolling with. You need you really need to get an attorney, or you really ought to get an attorney to draft that commercial lease for you.
Because those leases need to be tight.
Yeah, man, they do. And it needs to think about things like insurance and liability for people if they're coming in and going to have an accident in the place, and stuff like that. So it's very important to have well drafted leases in general, and a well drafted lease is the precursor to a good landlord and tenant relationship, because when things are not addressed or things are silent, then you have misunderstandings and you have mix-up. And let me tell you, it's not cute when you have mix-ups between a landlord and a tenant.
Absolutely not. I can just, like, I'm not in that situation, and I can feel the anxiety.
You know, and you as a landlord, just getting somebody out.
Yes.
But that's an episode for another time.
All right, Gabrielle. So if you could just give us a few words to wrap it all up, what would you say?
Wrapping it all up, I'm going to say again, get an attorney to look at your lease. Especially, if you're even like a real estate investor and maybe you have lots of properties renting out, make sure that at the very least you have an attorney help you to devise a template that you can use that is ironclad to protect your investment, because it's your property. Similarly, as a tenant, you have rights. Your landlord not supposed to just come in on you and do what they feel like because they're the owner. That is not how it works. They have rented the property to you. They are not allowed to just show up so. Right? So it's very important in the landlord and tenant relationship that each party know their rights.
Yes.
Really advising that you get an attorney at law to guide
Both
of you, right? And that will kind of pave the way for you to have a good relationship.
All right. Well, this is so good to know. I know the landlord and tenant relationship, particularly in Jamaica, is one where it can get testy. There can be a little bit of a struggle, but thank you for talking us through implied covenants and express covenants being promises that I have made to my tenant as a landlord and that my tenant makes to me. So this was a great episode, Gabrielle. Thank you. Thank you guys for joining us for another episode of Law Street. We look forward to seeing you next time.
Bye. If you found this information helpful, you can visit our website at www.ghrlegal.com to access this information in article form, along with many, many other legal subjects in Jamaica. If you like this episode of Law Street, be sure to like, share, and subscribe. Hit that notification bell and join us for more episodes. This show is for general discussion purposes only and does not constitute legal advice. If you would like legal advice, you should book a consultation with an attorney at law.